let's go back to the tally of the state applications. You're talking about hundreds of years of applications, dusty old applications. Your group, Goldwater Institute, Compact for America, took a look at all the applications, I assume, at some point. And what count do you come up with for applications? How close to the 34 state mark are we, according to your group?
Actually, we're trying not to count those because I don't think enough of them are sufficiently identical to really make a hill of beans. And to be blunt, none of them carry any contemporaneous current political will. Even if 30 years ago we had 15 applications that were identical, I wouldn't want to advance those dusty old applications because, you know what, I pile them on a desk next to 19 new ones, and all Congress is going to see is 19 new ones, and it's not going to do anything. So, to be blunt with you, the Compact for America is starting from ground zero. We are not relying on any existing applications. And it's not, part of it is that I don't think they're sufficiently similar, but more importantly, we don't think there's any political will manifested in those. We want to manifest real, tangible, contemporaneous political will because in the end, I think that's the only thing that keeps Congress honest.
To me, that seems like construction. You're creating new hurdles for Article 5, these applications, when it specifically, it doesn't even mention amendments until, in that clause, until the convention is called. The applications are just applications, and that the suggestion for the amendment is just a suggestion with no real legal effect. And we're obviously held to the laws of our forefathers and past generations. Why wouldn't we be held to the applications? Why couldn't we count those?
I mean, again, there is what is and there is what ought to be. I don't necessarily agree with your interpretation of the word application, but even if I did, history shows it's meaningless. Look, there are hundreds and hundreds of applications out there. They haven't motivated Congress to do anything. So if your legal analysis were correct, I would still say, how many divisions do you have, to quote Stalin or something? I mean, the reality is there's no political will manifested in a open convention type application. Not contemporaneously, not even, certainly not that are 50, 100 years old. What you have to do, as with all of politics, is you have to manifest contemporaneous, meaningful political will that means something to the careers of the people, the creatures that populate Congress. If you can't do that, you're not going to get a reaction out of them that is reliable. You might sometimes, I suppose it's possible that, you might get lucky that, simple majorities of Congress will do the principled thing, but you don't usually get to Congress because you do the principled thing. You do usually get to Congress at the near pinnacle of your political career, and that usually has involved some craven self-advancement. And so, I hate to say it, I like the founders' fundamental point of view, which is you balance ambition against ambition. You take, man's worst nature and you make sure that it's channeled to do the right thing. And in that same spirit, what I would like to do with the Compact or any Article 5 movement is make sure that we manifest contemporaneous political will that actually wields a real carrot and a real stick for those people who stand in our way in Congress, because in the end they do have to call the convention. They do have to refer out the amendment. So, we can debate the theory if you want to. I'll debate the theory with you, but
I got to go back just because we've got it on our website. We counted 42 what looks to us as legal standing applications. Actually, we took the Judge Tom Brennan's the view of these applications and how they count up what makes them valid legal standing applications, and we've got 42 states counted up, and we've got the actual applications. We don't want to debate theory either. We're looking at the black and white images from the congressional record, and in most of these it says that this application will be a standing and continuing application until 2/3 of the states have called for this. Does that clause, I mean, even with that clause where it even states in there's no sunset clause, this is a continuing application for an Article 5 convention, that also, you would say, we can't be held to that standard.
Well, no. Remember, you got two debates going on. Right now you want my legal theory response, and here's my legal theory response. You're not going to like what I'm about to tell you.
That's okay.
Look, here's the problem with the theory that non-identical applications can be tallied together under Article 5. It's a very, very, I think, to me, irrefutable legal argument, and it's this. Federalist 85 says that Congress's power is preemptory. That's the words that Alexander Hamilton used. Now, preemptory at the time was a name given to a kind of writ. A writ is a petition that you could file in court. An example of a preemptory writ would be mandamus. But the characteristic of the act that is preemptory is that it must be ministerial in its nature. It cannot involve judgment. It cannot involve discretion. It cannot involve policy determinations. And so here's the fundamental problem you have with asking Congress to tally up non-identical applications. You, on the one hand, are saying that Congress's duty is ministerial, non-discretionary, and non-policy based. And on the other hand, you want them to have the discretion, the policy judgment, the and the freedom to decide what is close enough, what isn't close enough, what are magic words, what are not. And you can't have it both ways. I mean, either Congress has a ministerial duty where it acts like a robot, you feed it, identical applications and it spits out a call, or you have Congress having discretion and policy judgment, and you feed them a bunch of different applications of different language, and you say, well, now you got to figure it out and then render a call based on your judgment. You can't have it both ways. And so, my legal judgment is founders meant for Congress to have a ministerial, non-judgmental, non-policy based role, and because of that, of necessity, our applications have to be near identical, so that what Congress does is basically robotic. If you throw a whole bunch of stuff up at Congress and they're not identical, you're asking Congress to exercise judgment and discretion that it doesn't have, and you're opening the door to them sitting on it and not doing anything.
Well, I honestly, I don't see where it says anywhere where the applications have to be identical, received within a 20-year period or anything like that. Again, it seems like there's more criteria being added on to these applications than what is laid out there. In Federalist 85, again, it says that there's not even supposed to be any debate over this particular thing. So counting up the applications, you can debate whether they're actual or not. But if you take away the debate, you're just counting. So to me, I look at that Federalist 85 argument, and it seems to me that they don't have the choice to really say, this is a good application, this is a bad application. It seems to me that the only role that they have is just, has this requirement been met? But is there any case that says it has to be identical amendments?
Not yet, no. See, but